Good afternoon, everyone. Welcome back to Business Law 1. Today we're going to be looking at Chapter 9, which involves the agreement. So we're kind of delving deeper into the world of contracts. I want us to be able to understand, in terms of our learning objectives, what a contract offer is and what proposals, how proposals are not offers, I should say. How offers are communicated, definiteness regarding the offer, how long an offer is good for, and then once it's accepted, who can accept it, and then when acceptance is effective. So that's going to be the overall kind of like framework for this chapter as we go through chapter 9. Anyway, when we talk about the requirements for an offer, what we're looking at here is first that the offer has to have actual intent. So if you remember when we discussed last week, kind of like the essential pillars of an agreement, there has to be an offer, there has to be an acceptance, there has to be consideration. Consideration is that bargain for exchange that kind of goes back and forth. Regarding the intent for a contract, intent can be deemed as lacking if the statement is merely an invitation to negotiate. So if I have a car that I'm thinking about selling and I am talking with you saying, yeah, I'm thinking about selling my car, I'm not really sure. That's not an offer. I'm kind of like, maybe fishing, for maybe an offer from you. I may be kind of just mentally kind of debating, do I want to sell my car or not? But in terms of the requisite kind of contractual intent, that would be lacking if I'm just kind of pondering or thinking about, um, maybe selling or not selling something that I have. Likewise, when we talk about newspaper ads, price quotations, catalog prices, pricing that occurs online in many cases, those are usually considered invitations to negotiate. So from a business perspective, there was a great example, I think it was back in 2006, 2007, Sears, they started offering I think it was the first generation Apple iPad. And so they had on their website, like you guys know, you go to websites and, you click on the electronics section and, you kind of filter through all the different options. And they had like computers and then they had tablets. And so they were selling this Apple iPad. And the price that they had listed was $69.99. And obviously, that was a mistake in terms of whoever handled the administration of their website, because it should have been $699.99. So, Sears was getting flooded with a bunch of orders for this Apple iPad, and they were kind of like at first wondering, well, what's going on here? We didn't expect the volume of sales that we're getting through their website. And then they soon realized the error that was made. As just a matter of legal principle, we're not going to hold Sears accountable for the mistake in the advertising because, again, ads, whether they're in print or if they're online, are just considered invitations to negotiate. Mistakes happen, and as long as it's not like a predatory practice, which in the case of Sears it was not, then they issued full refunds. They apologized to customers and said, look, if you do want to purchase it, this is what the actual or the correct price is. So again, that in terms of that intent, obviously Sears did not have the intent of selling those iPads so inexpensively, and we're not going to, kind of compel or force them to, because, I mean, Sears obviously at the time was this huge corporation, but you could imagine if it's a smaller business, if we're going to hold, mistakes in advertising uh, against these companies, you could put a lot of companies out of business. And so, just as a matter of legal principle, that's how we usually handle, such price quotations or ad prices. An offer does have to be definite. So, we'll talk about there's some exceptions with regards to price and quantity, but normally it has to be fairly explicit. It's like, okay, this is what I'm selling. It's going to be communicated to the offeree. The offeror is the person who's initiating the transaction. The offeree is the one who hears it, and then they get to decide, do I want to accept this offer or not, or do I maybe want to negotiate? But so you just kind of get a feel for like the labels that we affix to the different parties. But normally, it has to be fairly clear. I want to sell you my car. It's and I give you the make, the model, the year. It's very clear. in terms of what is being conveyed here. And so, again, that's part of that definiteness. We can, if we have an established relationship, so let's say it's a supplier or a vendor to, maybe a wholesaler or retailer. It is possible that based on like prior like experience in that relationship, that maybe you can kind of like fast track some terms, and so it could be easier in order to facilitate the sale. But that again, that is an established relationship. But normally, if it's a brand new relationship that's being created between the seller and the buyer, we've got to be clear, and so there's no ambiguity for either side. Revocation, normally an offer may be revoked at any time by the offeror, so the one who's initiating the offer, as long as it's performed before there's been an acceptance. That's the general standard. Any attempt to try and revoke, an offer after an acceptance has occurred, normally that has no effect. So if I say I'd like to sell you my car, this is the price, you say I accept, and I'll be by in an hour, tomorrow, whatever, with the purchase price. When you show up, I can't say, oh, I changed my mind. So it's like we've come to terms with regards to the sale in that particular transaction. Other ways in which offers can be terminated. So if I make an offer and you just are like, no, I'm not interested, so obviously that terminates my offer. If you counter offer, a car is a good example, I think, with this. So if I say I'd like to sell you my car for 10,000, and you're like, well, I'll give you 9,000. You are rejecting my initial offer, and so that offer no longer exists. And you are actually becoming the offeror, even though I still own the vehicle, because you've made now an offer of $9,000, and I have to decide, do I want to accept that or not? And again, if I accept it, then we have a deal. If I don't accept it, I'm terminating your offer. And I may say, okay, not 9,000, how about 9,500? You know how people can haggle. And so I have a flow chart that I'll show you in just a couple of slides, and it pretty much lays out, like, in terms of the potential responses by an offeror to an offeree, and then how you can kind of cycle through that flow chart until hopefully you get to an agreement that the parties will be bound by. Another way in which offers can be terminated if there's a lapse of time. Normally, depending on the goods, if a time period is not specified, which you could say this offer is good for 2 weeks or 30 days, and then if you go past that, it's an expiration. So that's simple. If it's not clarified or qualified, usually what we'll do is, depending on the type and nature of good and the industry, we'll kind of by default go to what is reasonable if no time period is stated. If either party dies or becomes disabled, or maybe if there's a change of law that makes whatever it is you're contracting over illegal. A change of law, whether it's local, state, or federal, can have that effect. And again, it just reinforces that general principle. We're not going to enforce a contract that violates law. There's no way that a court is going to do that. When an offer is accepted, then it usually is at that point a contract arises. So we have the offer, we have the acceptance. Folded in with that also is this idea of consideration. So we've gotten through whatever the price negotiation aspect of this whole process. But when we say there's acceptance, we're kind of folded into that the consideration aspect as well. And so ordinarily when we talk about acceptance, silence or failure to act, usually that does not constitute acceptance. So if I send out like a blanket, like if I canvass a neighborhood, let's say I have a lawn mowing company, and I mail out to everybody in this subdivision, contact me if you do not want me as your lawn care provider. And so I just start showing up one day and I'm mowing everybody's yards. That's not how you can't do a contract in reverse like that. There has to be an affirmation that is very clear, whether it's verbal or written, but the acceptance has to be clear. I can't just say as the offeror, well, if you don't do anything, then I'm going to take that as acceptance. That's not how this process works. This is the flow chart that I was talking about. And so you can see at the very top, it says, the offeror makes an offer. And then there are basically three options. The offeree, the person who hears the offer, they can unconditionally accept it. And if that's the case, we have a contract. If the offeree rejects it and says, no, I'm not interested at all, then obviously no contract arises. And then in the center, what we're looking at here is where the offeree changes some aspect of the offer. So that's where you have the termination of the initial offer, and the offeree becomes the offeror, and that's that haggle type situation. And then, you can kind of just keep spinning through this if you end up haggling until ultimately, the two sides come to an agreement with regards to consideration. But again, this just gives you a more visual way of trying to kind of process how this kind of plays out. Normally, an acceptance does not constitute, or does not exist, I should say, until words or conduct demonstrating assent to the offer is communicated to the offeror. So, if that's in person, that's an easy situation. You look at my car and then you tell me right there, okay, I accept. I want to purchase your vehicle. If you're maybe on the telephone and you're cold calling clients as like a salesperson, and the other person on the other line says, okay, I'll agree, I'll purchase this quantity, this type of good, delivery within whatever the agreed upon time is, 2 days, 5 days, whatever it is. There is something, and it's kind of an antiquated rule, but it still does apply. It's called the mailbox rule. And you can opt out of this if the contract specifies that you're opting out of the mailbox rule. But essentially, what the mailbox rule states is that acceptance by mail takes effect at the time and place when the letter is mailed, or if it's an electronic type system, so if it's a facsimile, if it's an email, upon dispatch is kind of like the language that they look at. Then even though the recipient doesn't receive it until sometime later, acceptance is as of when it was sent. So again, let's say you look at my car and I say, okay, I'm going to give you till Friday to decide if you want to purchase it or not. If you don't decide by Friday, then I'm going to go with someone else to sell this vehicle. So and if I have no language, if I don't talk about the mailbox rule being opted out, then if we get to Friday, let's say Friday you put in the mail, through the postal mail, I accept. And, maybe here's a down payment and I'll pay you the balance, Monday when I see you or something. I'm not going to get that envelope or that letter probably until Saturday or Monday. And so Friday's going to come and go, and I'm going to be thinking, well, okay, we don't have an agreement. And so, obviously when I get it 2 days later, or however long it takes for the post office to get it delivered to me, I am bound by when you mailed it, and you did satisfy the Friday deadline because that's when it's going to be postmarked. So it's kind of for industries that don't like to even fool with the mailbox rule, you can just put it as part of your boilerplate in the contract. We're opting out of the mailbox rule, so that doesn't apply. It's you have if Friday is the deadline, you have to make sure I am told on Friday. There's and whether you do it in person, if you do it over the phone, however you do it, it has to be told to me before the deadline. Other methods of acceptance. So the law, over time does kind of, adjust and is amended to reflect new technologies in communication. So obviously, telephone, you can conduct transactions over the phone. Now, obviously, with emailing, text messaging, tweets, it's kind of I don't necessarily think many contracts are formed through Twitter. It's possible though, and again, the standard would be upon dispatch if we're looking at the acceptance aspect of this. For years now, we've had automated ordering system. If you think of like just-in-time inventory, that's something that dates back to the 1980s. And so, what we have done now is we have automated the inventory process in a lot of companies. And so as inventory levels drop, as customers purchase things off the shelf, you can program an ordering system so that it automatically orders to replenish inventory. And so sellers have, computers on their end that receive and communicate all of these orders that are automated by buyers. And so, we have computers now that are buying and ordering, and they're actually entering into contracts. And so humans are not even involved. They were involved at the initial programming, so when you get to a certain inventory level, it's like, okay, let's automatically order this certain quantity. Again, through technology, the law does make changes and does amend itself to kind of reflect these new trends that are occurring in the marketplace. The last slide that I have for this chapter involves auctions, and so in an auction sale, technically, when the auctioneer is asking for bids, that is the invitation to negotiate. So I'm sure we've seen like auctions, like on TV, or if you've actually been to an auction house. This also does include auctions that are online, so like eBay and other sites that exist. So if someone is making a bid, they are making an offer, and acceptance occurs when the highest bid by the auctioneer is announced. And so customary with most auction houses, whether it's online or in the real world face to face, it's at that point that once the acceptance occurs of the highest bidder, then that's when the contract arises. And usually payment is expected at some point, either immediately after the auction closes, or with whatever is agreed upon. It could be within 24 hours, 72 hours, depending on the seller and the rules they create. The other aspect of auctions that does come up is if the auction is being provided like with or without reserve. So without reserve means that whatever the highest bidder is, it goes to that person. The risk you run with doing an auction without reserve is that you could have something that is valuable that does not go for as much as you had hoped, because it's contingent on whoever is present during the bidding process. If you do have a reserve price set, then that's a minimum. And so if the highest bid does not match your minimum, then the sale doesn't go through. And you either have to re-auction it, or you delist it, or whatever you decide to do. Anyway, so this kind of goes through the acceptance aspect of that element of contracts. As you have questions, please feel free to reach out to me anytime, but have a good, safe, and productive rest of your day, and I'll be chatting with you all soon. Thank you so much.